We thank you so much for watching Voices of the Bar, where the legal world speaks. And today we want to discuss capacity of cooperation. Capacity to contract, but capacity for corporations, companies. How do companies contract? Are they allowed to contract? And under here, we are going to discuss three areas that are very important under capacity for cooperation. One is the ultra vires principle, and then we shall discuss the incidental clause principle, and then we shall finally discuss the pre-incorporation principle. These are three that you must appreciate and know how companies cooperate, how can they be able to make contracts. Now, we ask you to subscribe, to share, and like our videos. Don't watch when subscribing. Just hit a subscription button. You lose nothing. Just hit and then keep following for more. And also turn on the notification bell, such that every time we put up a video, every time of anything, you can always come and be part of our interaction. So let us begin. Number one, people should understand that a company is an artificial person. That a company is that can be sued or it can sue. Okay, but it works under natural persons called the directors. A company is an artificial person that is liable to be sued, and also it can sue, but it operates all that under natural persons called the directors. Now, when it comes to capacity to contract, this one means that when do companies cooperate, contract? Can companies contract? Yes, they can contract. And number one, we have said companies are artificial persons, meaning that they can contract. And when you contract, if you default on your contract, you can be sued. Or if somebody does not fulfill their agreement, then you can sue them, meaning that companies can sue, companies can be sued. And we have agreed they operate under what we call the natural persons, which are the directors. Now, capacity to contract has evolved from time to time, but the first one, where companies are allowed to cooperate, is what we call the ultra vires principle. Now, under ultra vires, this one means that when you go away from the objectives for which you were set to do, then you are acting ultra vires. If a company does not work within the scope of what they signed under the memorandum of association, then they have done ultra vires. They have acted ultra vires from the principles which they are supposed to follow when operating. I'll give an example. If you go, the ultra vires principle means that if a company goes and registers one objective, that for us, our objective is to provide televisions, that for us we make or we sell televisions. Now, meaning that that is the objective for which that company has been set. Now, the moment we find them again dealing in lights, dealing in other things, phones, then they have acted ultra vires. Now, at common law and areas, companies were never allowed to operate beyond the scope of what they were registered to do. If you are registered as somebody who supplies rice, you cannot supply sugar. You stick to what you're doing. So companies were only allowed to contract when you are dealing in exactly what you were signed for. What is the objective of your company? Where you go beyond that, then there was a problem. Look at that case of Ashbury Carriage Corporation in versus Ritchie. Now, this company, Ashbury, were engineers dealing in engineering things, but they went ahead and got a contract to construct a railway line. Court held that they were acting ultra vires. This is not the objectives. So, when questions come under capacity for cooperation, they want you to discuss and say that companies were able to contract only on those things that they are registered for. It was static. The moment you go on something which is not under a memorandum of association, then you have acted ultra vires. So that is the principle of ultra vires. Okay. Now, we go to the incidental clause. As time went on, there came incidental clause, because now they were being too strict and rigid to companies, that companies could not companies were not allowed to open up and then form and make more profits and go to different ventures. Now there came later what we call the incidental clause, that now a company can operate under incidental clause. We mean that a company can now operate on the objectives which it was set for, and those other incidental things which come along. Now they have opened up. We now opened up, and even today a company can be signed of supplying rice, but it can supply maize, it can supply beans, it can supply matoke. That one company. So there are things which come along. What we mean by incidental clause. Now there was some bit of growth. And now companies are allowed to expand, to even venture in areas which were not registered in their objectives, incidental clause. Those other incidents which came in, you are supplying rice, but where you supply rice, they also want beans. So now you are allowed, even when this is not included in your objectives, you can go further and you can now work on those other areas. That is what we mean by incidental clause. I want to take something here briefly about the incidental, about what we call the incidental clause. In order to cover as many transactions as possible, most memorandum of association contain both the object clause and what is known as the incidental clause. For example, to carry on, engage in all matters connected with or incidental to the main object. You understand? Now, this meant that under the incidental clause, that companies would come when they are making their objectives, and now when they make the objectives, they put things related to what they are dealing in. If the object was to sell rice, you say, but if somebody asks for matoke, they ask for beans, they ask for soya, they ask for this, those are incidental. We can also supply them. We are trying to open up. Okay? At the time, the incidental clause was creating what we call it, trying to open up. Now, when they open up, that is why today, one company can register new objectives, that for us we do everything. And then you can operate. So you were allowed to contract under the ultra-vires principle, stick to the objectives. But under the incidental clause principle, you were now saying you work within the objectives, and those other areas related to your objectives, you can now venture into them. That is what we say incidental clause. And then we have the pre-incorporation principle. Now, the pre-incorporation principle, for it is very simple. That under here, they are saying that you can move and make a contract with the people, but when the company is not yet registered, that you contract with the people, but when the company is not registered, you don't have money, you have a hope of making a company called Law School Made Easy. Now you go to schools, you begin to contract with them under that company. Okay? So the issue is, can these people, can a company, when it is now registered, can it be liable for the contracts made at common law? That one was never possible. That the moment you go and contract, when the company is not in existence, then the company cannot even come and ratify in the future. It was not allowed. That where you come and you contract with people under a company name, which company does not exist, you are doing that on your own. That is what we mean by pre-incorporation clause. This clause was that people, at common law, it was very simple. That people would come and contract with people, but when the company is not in existence, you are just planning to open up a company, you begin to sign contracts with people. That one is on your own. At common law, even when the company was now eventually formed, it could not affect the company. Even when you say, let us ratify the contracts we made before the company was signed, it would not operate like that at common law. But later, as things now evolved, persons, if those persons who have made today, if you made a contract before a company was registered, now today you can ratify it, and then that contract becomes part of the company the moment the company later has been formed. When you form the company today, things have now changed. You can ratify, because it will be upon the directors to go and make the contracts they made before formulating of the company now operational, because now they are the same people who are working in this new company which has been formed. So that is the area. I urge you to read extensively about capacity for cooperation. So that is how we can summarize for you capacity of cooperation. Of course, there are many cases there. There is Kendall versus Baxter and very many other cases. We thank you so much for watching Voices of the Bar, where the legal world speaks. Subscribe, share, and keep liking our videos. Until next time, thank you.